Hello, I'm Patrick West with Patrick West Law Firm. Your first question is, how do I start the process? The process starts with a consultation. The consultation will be an assessment of your needs. We're going to assess whether there's a house involved, whether there are children involved, whether one party or the other owns business that needs to be resolved by the divorce court, whether there are retirement accounts that need to be resolved, whether there are debts that need to be resolved, what property goes to whom, and whether there's a need for a temporary restraining order. After that assessment, we'll draft an appropriate petition. That petition may or may not include a request for a temporary restraining order. What is a temporary restraining order? It's basically an order of the court. It doesn't award property, it doesn't award custody, it doesn't award anything. It keeps the status quo between the parties. Once that TRO if a TRO is necessary and is signed by the court, there will be a hearing within 14 days. Both parties will be expected to attend that hearing, and it's at this hearing that temporary orders can be issued by the court. Temporary orders can award a house on a temporary basis to one party or the other. It can award temporary custody of the children to one party or the other, and they can also award child support to one party or the other. If the matter is uncontested, it goes fairly quickly. After 60 days, the court can entertain a prove-up of a divorce decree, either an agreed decree or default decree if the other party chooses not to answer the petition for divorce that they're served with. At that prove-up, you'll be sworn in. The attorney will ask you questions in front of the judge, basically outlining for the judge what's contained in the final divorce decree. And then the judge will most likely sign that decree, and it'll be entered with the court, and you will be divorced. If a trial is necessary for a final decree of divorce, there may be some preparation required before a trial can be held. Preparation includes things like discovery, and there are two types of discovery. Discovery is written discovery, or it's discovery by deposition. Written discovery includes usually three things. Written interrogatories, and those are questions that are posed to the other party that they must answer in writing. It may include production of documents, where the other party has to produce documents. This is especially the case where there are documents involved in a business, or the other party has kept separate bank accounts to discover what's in those bank accounts, or if there's retirement involved, things of that nature. And then there's a third type of written discovery called request for admissions. Requests for admissions are where you ask the other party to admit or deny certain facts. If they do not respond to those admissions, then the court can deem them admitted in your favor, and you can use that as a basis for seeking a judgment against the other party. The second type of discovery is oral discovery, or discovery through depositions. That's where you call in the other party or other witnesses. The attorney can ask them questions. There'll be a court reporter present. The court reporter will take down everything that's said during the deposition, and then we'll create a transcript of that deposition, which will consist of attorney questions and then the deponent, or the person who's being deposed, their responses to those questions. Depositions, depending on how intricate the issues are, they can be taken just with the court reporter present, or there may be a videographed or a video deposition taken. There may also be the need to assess the value of certain property, especially business property, if that's a contested issue, to determine how much one party, the non-business owning party, may be entitled to as compensation for the business that they grew together. The business, or that may involve having an expert come in and assess the value of that property. The expert may be somebody the parties can agree upon, or both parties may hire their own experts. In any case, that's a necessary step, and there may be other experts that need to be retained in order to assess the value of other property or to determine the value of a house, things of that nature. Once all the discovery and the experts are all designated and the discovery is completed, then you move on into the trial phase. And a trial phase is where the parties will actually go to court. They'll each be entitled to testify. They'll each be entitled to bring their own witnesses, and the court will assess the witnesses and the testimony of the witnesses and the evidence presented, and then enter into a decree, or enter a decree or a judgment against both parties, or against one party, or for both parties, depending on your perspective. Before you get to the point of going to a final trial, Tarrant County judges really like the idea of mediation. They want parties to mediate their disputes. And mediation can consist of mediation over property, determining who gets what property. Mediation can include what the value of a business is, to try to reach some agreement on the value of a business. It can include who gets retirement or who's entitled to the retirement between the parties. Mediation can also involve who gets custody of the children and child support. Child support in Texas is really a matter of statutory law, and it's set by statute in most cases. And so the courts have a formula to determine child support. The important thing is to determine what needs to be presented to the court to maximize child support from one end, or to minimize child support and maximize what you've got to spend on the children if you're the non-custodial parent or the parent that doesn't have primary custody of the children. Visitation can also be an issue, but it's largely determined by Texas law. Essentially, both parties get almost equal visitation under the Texas statute. Just a very little bit of difference between the primary custodial parent and the non-primary custodial parent is found in the law. Once the parties either mediate an agreed settlement and then go to approve up with the court, they're divorced, or if they go on to trial and the court determines all the issues, then the parties will be divorced and free to pursue their own lives. Depending on your particular circumstances, I'm sure you have many more questions. Just give me a call at 817-332-2600. My staff will be happy to set an appointment for a free consultation, and I'll try to answer your questions at that consultation.